Establishment Act and Economic and Financial Crimes Commission Establishment Act. What it means now that with the establishment of those two bodies, federal bodies, Section 15(5) of Chapter 2 of the Constitution becomes justiciable. It means it can now be enforced. Now the issue, the controversy is whether or not the State Assembly equally has power to make laws under the state. The argument has been that Section 13, ordinarily laws regarding crimes and others, which nowhere appear in both exclusive and concurrent legislative lists, should be regarded as residual powers for which only the state government has powers, can legislate on. But if you look at Section 13 of the second schedule of the Constitution, that Section 13 enjoins government to observe or ensure the observance of the provisions of that chapter, which is directive principles of state policy. Now, when you go to Section 318 of the Constitution, which defines what a government is, you will see that it defines government to include federal government, state government, and local government, meaning that a state government can make law to enforce that section. In the final analysis, all that it means is that issue of financial crimes becomes, or abolition of corruption becomes concurrent to the extent that the state can make law on it, the federal government, National Assembly can make law on it.
Let's say, where I want to come in here is, you know, when there's also the argument that each state of the federation, we operate a federal system, each state of the federation also have their own criminal code laws, separate from what is applicable at the federal level, which is applicable in the FCT, for instance. So, to the extent that they're able to establish these criminal code laws in their respective states, even while the federal government also has, you know, a criminal law, that the Administration of Criminal Justice Act, which applies in the FCT and other states for federal crimes as well. To that extent, does it not also mean that state governments, like the Lagos state government, can also set up, because the law on anti-corruption is a criminal law?
Yes.
Does it not also empower them to set up that kind of law?
That's why I said, because the law had become concurrent by reason of the definition of government in Section 318 of the Constitution, and the fact that Section 13 enjoins government to abolish corruption, it now becomes concurrent. But you have this Section 4, subsection 5 of the Constitution that says that if the law made by a state on a subject matter conflicts with the law made by the National Assembly on the same subject matter, that of National Assembly will prevail. So it doesn't stop a state from making a law, but provided
area of conflict.
Yes.
Has this been tested in law?
Of course. Of course. For example, in the case of Attorney General of Ondo State versus Attorney General of the Federation, the argument was that the ICPC was in issue.
Yes.
That the ICPC is unconstitutional as it seeks to usurp the functions of the state penal legislations.
Yes.
It was argued that since Nigeria is a federation, that no arm of no tier of government will impose itself on another tier of government. It was an extensive argument where Professor Ben Wabueze was an amicus in the matter. You have Olisa Bakoba, eminent Attorney Generals of the entire taxi states. But at the end of the day, the court says, look, when you talk about...
This was before the Supreme Court?
Yeah, before the Supreme Court. This was before, in 2000 and...
it should have been 2004 or so.
Yeah, but around that time. So what the Supreme Court said, when you talk about federalism, you talk it in general terms, the ideals. But when the Constitution makes specific provisions, that Constitution may adopt its own federalism. Yes. And in our own, Section 4(5) of the Constitution has said that if you make your law, even if it's within your legislative competence in concurrent legislative list, and the National Assembly makes its own law within its own competence, being in concurrent or exclusive legislative list, that insofar as there is a conflict in the law made by the state and that of the National Assembly, that National Assembly must prevail. And that is our own constitution, our own ground norm. We cannot import the idea of federalism from other climes completely without reference to our own specific laws.
But let's still talk about the issue of federalism and how it operates, especially as it has to do with law making. For the federal government, this is about ensuring that persons who have perhaps dipped their hands in the public till as far as the resources of the state is concerned are held to account. But we've also seen cases where sometimes some of these cases are pursued based on political interest, and the states have had cause to resist and said, we haven't made any complaints that any money is missing by any public official who had served in the state, whether serving or former. And based on that reason, some persons feel not all cases pursued by these federal agencies set up by the National Assembly are actually altruistic in nature. Some may be, out of, political interest of certain persons in the center.
Well, it will be unfortunate if that happens, but then the law is the law. We don't have to mix it with morality. Even if it is out of political interest, provided that you have infringed the law, it doesn't matter whether he's now coming to use it as a political tool to deal with you.
Let's talk about,
if you don't want to be dealt with, don't infringe the law at all.
Let's talk about the states themselves. Could the idea of setting up an anti-corruption agency also be a political tool by themselves to, take themselves out of federal scrutiny? Because I look at that law set up by Lagos State government, and certain sections in the law is quite interesting because it tends to oust the jurisdiction of federal anti-corruption agencies like the EFCC and the ICPC from investigating or prosecuting any individual of the state. And it even goes as far as saying any such case that is pending must be terminated.
That is where the inconsistency rule comes in. How can you oust the federal agency from the law competently made within its legislative competence? You cannot do it. That is where Section 4, subsection 5 of the Constitution comes in to invalidate the one they have made.
I still remember that in the case involving a former governor of Delta State, James Ibori, the Delta State government made some position, canvassed his position in that case, and said you can't begin to ask questions about the resources of the state, and in the first place arguing strongly that none of its money were missing, and they weren't complaining that any of its monies
you don't have to complain. Missing. You don't have to complain. Let me give you one example. If you see a thief, you are empowered by law to arrest the person and make him over to the police. You don't have to wait for somebody to come and report there's a thief. You get my point? So if the agency, through whatever means, they discover that there is some infringement of the law, they don't have to wait for somebody to come and complain. They are enjoined to enforce the abolition of corruption. That's my own take on that.
Let's look at that controversial section 13, actually, sub 3. The Commission shall, upon the commencement of this law, take over the investigation of all anti-corruption and financial crime cases involving the finances and assets of Lagos State government being investigated by any other agencies. It adds, the Commission shall have the power, to the exclusion of any other agency or body, to investigate and coordinate the investigation of corruption and financial crime cases involving the finances and assets of the state government. By virtue of this provision, are you foreseeing any conflict that is likely going to arise between the Lagos State government and the federal government?
Even on the face of it, you don't even talk about foreseeing. On the face of it, there is conflict. When you say that you will take over investigation being carried out by any other agency, and we know that we have EFCC and ICPC, and then in section 13(5), you said to the exclusion of any other body, it is only the Lagos State
Public Complaints
Anti-Corruption Agency that will do. There is, on the face of it, there is conflict, even without going into the nitty-gritty of the provisions.
Could there be a motive to this kind of case? To this kind of law, for instance?
I'm not a politician, but being a person who lives in the society, one can hazard a guess that there is motive for making that law. Particularly so when it's in public domain that certain officials of Lagos State government, past officials of Lagos State government, and even present officials are under investigation by the EFCC. So one can hazard a guess that it might be the motive behind the passage of the law. But as far as the law, our constitution is concerned, that law is dead on arrival.
But for that law to be dead on arrival, it will still require a pronouncement of the court.
Of course, it will.
So this is possibly going to go through
of course,
litigation?
It will. Definitely it will. But I am telling you from the decided case by the Supreme Court of Attorney General of Ondo State and the Attorney General of the Federation, except if the Supreme Court now decides to overrule itself, that law is dead on arrival.
Honorable Sir, and I'm wondering what this implication would be on, say, the investigation that is EFCC or maybe the ICP is handling involving individuals, influential and politically exposed individual in Lagos State. Where, for instance, this case of this legislation, conflict of this legislation goes to court, what's likely going to be the impact on the investigation being carried out currently by the EFCC?
Well, as law-abiding institutions of government, if there is a challenge of its power to investigate and prosecute, I think as a responsible government organ, they should wait until a pronouncement is made. But as I've told you, I don't see, except if the if the Supreme Court decides to overrule itself, that law is dead on arrival.
But does a mere filing of a case in court put on pending mode?
No, it doesn't.
An investigation by a statutory agency of government?
It does not. But all the same, as a civilized society, you don't have to preempt the court or undermine what the court will do at the end of the day by, okay, they say, don't do this, wait, we are trying to get interpretation and you continue to do it. If at the end of the day, the court says you don't have power to do it, you have wasted public funds, public resources, and even time in doing those investigations.
I ask that question because when you look at the provisions of the Administration of Criminal Justice Act, as it applies to, financial crimes cases, when those cases are in court, at the trial court, and there's a situation where there needs to be an interlocutory appeal to the Court of Appeal, based on the ACJA 2015, it doesn't operate as a state.
But this one we are talking about investigation. if the trial has commenced, then we talk about Administration of Justice, Criminal Justice Act. But this one, we are talking about investigation.
What's the difference between investigation and trial? Because it's still a process. It's a process.
If you have concluded investigation, you commence trial. But in this one, like from the question you asked me, whether they will continue with the investigation. And I said,
whether they should statutorily continue with the investigation.
Statutorily, they still have power to continue with the investigation. But I'm talking about now behaving in a civilized manner, to the extent that you will not undermine the courts or preempt what the courts will do in fact. You ought to hold on and wait the outcome of that litigation. But ordinarily, statutorily, nothing stops them from doing it.
Let me ask you, I mean, as we're rounding off, what do you think would be the fate of, you know, financial crimes committed by politically exposed persons at the state level? If, for instance, the court eventually says, EFCC, ICPC, you cannot look into what the states are doing. Allow the states anti-corruption agencies, for the states who have passed that legislation and signed it into law, to handle it.
That will be a disaster for this country. We all know that governors are emperors. They determine whatever happens in the state, even without regard to state legislature. We cannot deny that. We all live in this society. I am not a politician, but I live in the society, and we see what happens on a daily basis. We read what happens on a daily basis. We know the attitude of governors. They behave like the lord of the manor. Nobody controls them. The state legislature are mere rubber stamps. They don't control them. If the court rules otherwise, it means that the governor can loot the treasury of the state, and the state anti-corruption agency might not be able to go after him because he controls the anti-corruption agency, as there is nobody checkmating or ensuring checks and balances, knowing that the state legislature are appendage of state government houses. It will be a disaster for this country.
We want to see how this particular one pans out. I want to say thank you so much, Mr. Ikechukwu Ezechukwu, Senior Advocate of Nigeria, for joining me on this conversation.
Thank you so much for having me.
Well, that's Project Justice for this week. Thank you so much for being there with me. On behalf of the entire production team, I am Utibe Umoren. I'll see you next time.
AIT, sharing the African experience.
General De Leon.
General Chago.
Looks like you missed me.
A cruel battle between two warring factions.